today we are talking about estate planning, something I'm guessing might be last on your mental list of I can't wait to do this tasks. Believe me, I hear you. Yet you are here staring summer break in the face, which I know makes Brianna and I very happy because we can do this together. And a lot of parents hear about special needs trusts, but don't realize that full estate planning is equally as important. So what does estate planning even mean? You might be wondering if this applies to you because you don't own an estate, but trust us, if you're breathing, this applies to you. So today you're going to leave knowing how to prepare for your meeting with an estate planner. You're going to have a list of questions to ask about medical and financial decisions if you're unable to make those decisions yourself. And we'll talk about appointing someone or several someones to be charged with distributing and handling your assets. This is your crash course in estate planning. Brianna perfectly summed up the importance of planning for your and your children's future. You need to ensure if you're not here, the wheels of your family keep on turning. So these are things we don't want to think about, but it's one of the most important things you can do for your family. So let's get organized and hope we don't need any of this until we're 120 years old. So I'm Lindsay Crain, and I head the content and community teams at Undivided. And like you, I plan to be the most organized 120-year-old alive. I have a long way to go, at least for the organization part. And to help me and you do that today, we are thrilled to welcome Brianna Davidson Jarrett. Brianna is a former estate attorney and currently serves in the Maryland Office of Attorney General as Assistant Attorney General, representing the Maryland Insurance Association. She comes to this not only from professional experience, but personal. She's also mom to 3 children, one of whom was born with disabilities. Lucky Maryland to have her on their side. And because of her position in the Attorney General's office, you can't hire her for estate planning. And I think that makes her even more valuable. She's also not giving legal advice today. This does not take the place of sitting down with someone and talking through all of your legal options. She's here only to guide you because this is what she's trained for before she was even living it out in real time. So welcome, Brianna. We are so grateful for you sharing your time today.
Yeah, absolutely. I'm so grateful to be here.
All right, Brianna. So let's start with the documents that we need to set up that activate while we're living. We are the caregivers for our children. So if we're alive and unable to do everything that we currently do, we need to ensure that things are in place so our children's needs are still met. So what are the essential medical documents that every parent should complete that would communicate medical decisions if we're not able to speak for ourselves?
Yeah, so in different states, the title of the document may vary, but basically you want either one document or 2 documents that, and like in Maryland, we have one document that serves 2 different purposes, but you'll find in some states they kind of break them into 2. Mainly, you want the document to appoint someone to talk to your doctor for you if you could not talk to the doctor on your own. And in addition to that, you want to communicate what kind of care you would want in an end-of-life situation. So like I said, in some states, you'll find that both roles are kind of consolidated into one, and in other states, they're separated into 2 separate documents. In some states, they're called a living will. You'll hear them called an advanced medical directive, a healthcare power of attorney, but they all accomplish the same thing. It's the document that places authority into the hands of someone that you've selected if you could not talk to the doctor on your own.
Right. And so once we've, talked through I'll just call them sort of the living will documents, that with whatever name that is appropriate for your state. But so once we've talked through those living will documents with our attorney, what are 3 things that we need to do once we receive those drafts?
So one of the things that you'll want to do is to actually read the document. And it sounds silly, but when you sit down with an estate planner and you explain to them what you're looking for and what you want the document to say, and your situation may vary. I've seen folks who come from a particular religious background, and so because of that, there are certain medical procedures that they're very against or that they're very pro for, right? So you'll actually want to read the document after you get it and make sure it says what you want it to say. If you ask for certain provisions you put into the document, read it and make sure they're in there. And I think we mentioned in the article that these documents aren't written from scratch usually. Usually it's a form that's been adapted to your situation. So you might find as a result of human error, something that you want to be in the document isn't in there. A lot of times I'll sit down, I have in the past sat down with a person and read their document, and it turns out it says something that they had no idea, those provisions were there. So actually read it. The second thing is
I have to say, sort of like when you're reading your child's IEP and it's another child's name, right? So just never take for granted that it's written right.
Yeah, I've done that. Reading it, sometimes I've sat down with someone and they'll tell me, no, this has happened, in my former life as an estate planner. One of the first questions I'd say is, hey, did you read it? I sent you drafts. Did you read them? Yeah, definitely. I read them. Really? Because your name is spelled wrong on the first page. So you failed that test. Because sometimes I've had people tell, if you feel very strongly about a feeding tube, for example, that you don't want to be kept alive with a feeding tube, a medical document, that's one of the hot button issues across the states, and different states deal with that. In specific ways. There are different laws governing feeding tubes and when a person can have one and when they can't. So if you feel very strongly about that, make sure what you want the document to say is actually what it says. Chances are, if you don't see that it says that, it probably doesn't say it. So ask those hard questions. Don't think to yourself, this is legalese, it's boilerplate. I'm going to trust what the attorney tells me. Not to say your attorney is making a mistake, but just make sure you understand what it says. Definitely. The more questions you ask, the better, honestly. The second thing is to give a complete copy to your doctor. In an emergency, you don't want your healthcare agent, which is the person that you've selected to do this job for you. You don't want that person to have to be scrambling, trying to find where it is. I'm just saying, right? Like, we all have kind of a paper collection probably on our desk. I have one. It's behind this screen that I'm talking to you from. But you don't want that person to go scrambling for it. Usually, if you need an advance directive or a healthcare power of attorney, usually it's an emergency, right? So if your doctor already has a copy of it, they can easily fax it to an emergency room. In most states, a copy, or in some states, I'll say, a copy is just as good as the original. So those, I find it to be very helpful. If the doctor already has a copy, then you can cut out that piece of it. And the third thing is to just—
Can I ask you something about the second one? Sorry, Brianna. This is probably a ridiculous question. So when you say doctor, does that mean like your primary care physician, even if you see him like once a year for a flu shot or a physical, that's really, they still should be sort of the keeper of something like that, because that's the call that, which I know we'll talk about, whoever it may be, that's who they're going to contact, to make sure that. Okay.
Yeah, I usually say give it to your primary care. I mean, with exceptions to every rule, if you yourself have a condition for which you see a specialist and you see that person pretty often, give them a copy, but if it's your primary care and you're a pretty well person, you only see them once a year, still give them a copy. You can always tell them, hey, this year I signed an advance directive or healthcare power of attorney. I brought it along with me. Can you just do me a solid and make a copy and keep it in my chart? They're not going to say, absolutely not. We will not be doing that for you.
If they do, maybe get a new doctor to your
right, exactly, yeah. Yeah, and the third thing is just to actually talk to the person that you've selected to make your decisions, and make sure they know what your wishes are. I know that can be a tough conversation. I don't know of anyone who would really look forward to that kind of conversation, but it's necessary, because after having that conversation, what you're doing is not placing a burden on that person to make these decisions for you. All they're doing then, if they know what your wishes are, all their job is to communicate to your doctor what you've already decided. They already know how you feel about this stuff, so they're just communicating it to your doctor if you couldn't do it on your own. So that's why the conversation is important, in my opinion.
Right. And so we have copies with our doctor, copies with, obviously, our person, the person making our medical decisions. Anybody else, anywhere else that we should have that?
I just personally, I usually say keep it one in the glove compartment of your vehicle. Just human life and being what it is, honestly. If you don't want to know what's in my glove box right now, I think there's a whole roll of toilet paper in there, honestly. But yeah, do keep a copy in your glove box, because if in an accident, I know that a lot of times people check there to see, who's your emergency contact. It's not, I will say, there is sometimes confusion about whether you're signing a DNR. A DNR is something totally separate, and that's something you should absolutely talk to your estate planner about. A DNR is a medical document. It's signed by a doctor. This is not a DNR. So this is not the document that would stop a paramedic from coming and getting your heart pumping again. That's not this document. And most people in most states, and at least in Maryland, you can't get a DNR unless you have a condition that your doctor says, yeah, you definitely don't want anyone pumping on that person's heart, if something happens. This is totally separate from that, if there's any confusion.
Right. So don't be scared that, I think that's a great point, that the paramedic is going to find that in your glove.
See it and say, yeah, forget it. Yeah.
Yeah. So
no.
Next, right? Yeah. Okay. Got it. Okay. One more thing to add to my glove compartment, of which I have no idea what's in there. So then if we switch gears a little to financial decisions and power of attorney. So if you can first define, just in case, people might have lots of ideas in their head, what does power of attorney mean?
A power of attorney is like a cousin to the medical document. It's similar in that it's only effective while a person's living. So it has literally no effect after you pass away, but it's for financial and legal matters. So the purpose of that document is to put authority into the hands of an agent, who can sign your name for you on a legal document, who can pay your bills for you. That is the purpose of that document. And different states handle this differently. At least in Maryland, I can tell you that if you don't have a power of attorney, and a lot of married people kind of assume they can sign for each other, which is sometimes true, but sometimes not. So a power of attorney, and especially if you're in a non-traditional relationship or you have a partner that you live with, but you're not married, those kinds of situations, especially, you need a power of attorney. But I usually say, look, if you're 18, you need a power of attorney. If you're an adult and you're not a minor child, nobody has authority but you to sign your name to a legal document, pay your bills, and do all that stuff, unless you have a power of attorney. So that's why that document is so important. Without it, if there's an emergency and if you are unconscious, God forbid, a lot of times you can't do anything unless a guardian has been appointed, and the term guardian varies by state. But a court would need to get involved to get somebody, who has legal authority to act for you.
Right. And I think something that you had mentioned to me before, which you just touched on, is that I think a lot of people assume if they do have a spouse or a partner and they're on all of their accounts, that, okay, there's no reason I don't need financial power of attorney because we're on all, I'm on all of their accounts, so everything's good. So right. why should people rethink that?
Well, because a lot of times married people own real property together, and you can't just sign for your spouse in connection with real property, right? Like, what if you were in the middle of refinancing, or what if you were in the middle of selling a house or purchasing a house? I've seen people use a power of attorney, they were within days of settlement and something happened to one of the people who needed to sign. But luckily there was a power of attorney. So it allowed, the one person to be able to sign for both. I've seen that happen many times, but also with regard to IRAs and retirement plan accounts, you can't have two owners on a retirement plan account. And a lot of people will say, well, my name's on my spouse's retirement plan account. Well, you're probably a beneficiary on the account. You're not a joint owner. It's an individual retirement plan account. The key word being individual. So only one person owns it, right? Lots of other examples, life insurance. I mean, you don't have two owners generally. You have a life insurance plan. But lots of reasons why you would need to use it. If you own a car in just your name and something needs to be done with a vehicle, a power of attorney, most of the time cars aren't owned jointly for liability reasons. But that's why you would need a power of attorney for that as well.
Well, and another question, and we got this a lot even beforehand. People are like, well, I don't own a lot of assets. So is a power of attorney, is that really necessary? Again, I think people are thinking, many people might think, well, if we don't have this great worth, do I really need that? Or that's maybe for somebody else.
Yeah. So the answer to that is, I think you'd have to own literally nothing to try to avoid a power of attorney. Because I know, there are young people who think, oh, I don't own anything, so or even parents of young kids who are kind of just starting out. But you probably do have a bank account that has your name on it. You probably do. You might have a group life insurance policy through your employer, right? Like, without a power of attorney, if something happens to you, no one can access that. Nobody. No one has authority to do any of that for you, or even to assign your name to a contract. If you needed to get care, like in a facility that was not a hospital, who's going to sign the contract? Nobody has authority to do that, right? Without a power of attorney. So for those reasons, also, you want to make sure that that document's in place. It's usually, not always, but it's usually one of the less expensive documents. And sometimes in certain states, there are what are called statutory forms, like a fill-in-the-blank form power of attorney that the legislature of that state has put together. Maryland has one. Other states have them as well. There's no cost to the document, and if you don't have a huge estate, but you know that you need that legal authority in place, not a bad idea to ask the estate planner, is there a statutory form that I can use for a power of attorney? Or honestly, sometimes they also exist for the medical decisions as well. You can ask them if that would be appropriate for your situation, find out why, and take advantage because a lot of states recognize why that document is so important. So they try and make it available to as many people as possible.
Absolutely, that's a great idea. I'm going to Google that as soon as I'm done. Many things. I'll be rewatching this, taking all my own notes. And I know you said that once we have that power of attorney set up, what are 3 essential things that we need to do with it?
Okay, so one is to select a backup agent. I have seen powers of attorney where only one person was selected to serve as the agent. And if, let's say it's my power of attorney and something has happened to me, I'm still living, but I'm not conscious, I can't make any decisions for myself, and I've named my spouse to be my agent, and then he passes away. Now it's as if I have no power of attorney. So you want to make sure you have at least one backup. And usually it's not a ton of drafting to just add one more person. You can't amend the document. If I'm not well, I can't amend it, right, and add more people to the document. Somebody else that's close to me, if I have a grown child, that person would have to go in front of a judge and ask a judge for permission to act for me. So you can avoid all that just by naming a backup to your first agent. I like to see, when I was drafting these documents, I would like to see 2 or 3 backups. On my own personal document, I have a pretty complex list of who's allowed to act and in what situations. So you can definitely do that, but at least one backup. And even the statutory forms, I think in most states will allow you to select at least one backup. Yeah. And secondly, this is kind of important, it's very important. Ask the person who's preparing your document when the document is going to be legally effective. I know a lot of people have some concerns about making the document effective right away. Oh, so as soon as I sign this and my agent is allowed to just go right into my bank account and can take all of my assets away, well, the person you've named to be your agent is usually a spouse. We're not going to sell.
And if you're that worried, again, maybe there's some more
I can't tell you how much, not to get into attorney war stories or anything, but I've had couples who've been married for 50 plus years to sit down and say, you mean as soon as I sign this, my spouse can go and access them? You're married.
And you can't be married and not put them, as power of attorney as well. So
right, or a lot of times they'll just bring it up right in front of the kids who their name, if it's grown kids who are serving, I'm just All right. Well, it's a revocable document usually. Okay,
Right.
you can ask your estate planner about that. But I when I did this work, I used to say to people, if your agent does something you don't like, guess what? You can rip up the document and say, forget it, you're not my agent anymore.
Right.
I mean,
oh, and I'm putting this up on screen because that's perfect. Iris had asked, yeah, does it remain the same until you change it or terminate it?
yeah, and it's easy. I mean, in Maryland, at least, it's easy to terminate. I say easy, but you would, if you've provided it, which we'll get, I mean, I'll mention this, but if you've provided it to your bank and they've got it on file, you'd have to then call them, right, and say, I've revoked my power of attorney. I don't want this person involved in my finances anymore. Tricky, especially if you're going through a divorce, right? That would be a tough thing. You'd have to go and kind of backtrack and get all that squared away. So that's annoying. But yeah, you're selecting someone normally that you trust is going to do a good job. And if they do misbehave, I mean, in Maryland at least, an agent is a fiduciary. So and they're held to a pretty high standard under the law. So you could always haul them in front of a judge and say, this person behaved pretty badly when they were acting as my agent. But before you would even get to that point, you could just rip it up and say, I'm revoking this. I don't want this power of attorney.
Right. Yeah. And number 3, I think you said kind of in the answer to that question, but that's giving a copy to your bank.
Yes. Yeah. Definitely. Because most banks don't have an attorney on site, right, who reviews these things. And I think you'll find that a lot of times, I had to do this for someone just out of my own personal experience. I was named as the agent under a power of attorney, but because I've had the background in estate planning, I knew what was involved in getting a bank to accept a power of attorney. What is the bank worried about? The bank's worried about fraud, right? Like they don't want anyone to come and sue them and say, you let someone access my account who wasn't me and I didn't give you permission to do that. So they're not just going to let you waltz in and hand them a power of attorney and say, now I need to access my my spouse's accounts and whoopsie, they didn't put my name on it. So they're going to review the document and their attorney's probably located hours away and you cannot call them and find out the process, like how long it will take. Meanwhile, you need those funds because you've got a hospital bill that needs to be paid. Okay, so to avoid all that, when you sign your document, I would go ahead and give a copy to your bank. They'll probably want to see the original and make their own copy. Then they'll send it to their legal team and their legal team will say, here's all the problems we have with it. And then you can deal with that while you're able to communicate with the bank. So much more difficult, right? If you're not well and if you're unconscious, God forbid. So yeah, go ahead and give it to the bank for that reason.
Yeah. Yeah. Again, I have not dug as deep as I need to into our estate planning, and maybe, and that's something where it's like, oh, I don't know if that's something that everyone talks about, but I, wouldn't have thought about, like, the medical power of attorney, right? The medical decisions to my doctor, to the bank. So yes, we're gonna have a nice little checklist after this of fun stuff to do. So these are, some of the essentials, obviously, some of the big essentials with medical and financial decisions that, that can be effective when we're alive. And so now to the stuff that we really don't want to think about, who handles all of the details of our lives when we're gone. And so, this will tiptoe a little bit into trust, but that will be a separate event and a separate article in which, we can dive much deeper. So we're going to first focus on the assets within estate planning. And so you, Brianna, you've outlined 5 decisions that we need to consider about the distribution of our assets. So can you review those for us?
Yes. So I know that this can be a really difficult, and it can seem really overwhelming to start thinking about how things would be divided up. I think a good way to think about it is you don't know what you're going to own at the time that you pass away, right? Like none of us knows. So it's best not to focus on what specific things are going to each person, but just kind of in broader terms. If you pass away and your spouse or your partner survives you, is everything going to go to that person? Sometimes no, right? Like, and if you each have kids that you've brought into the relationship, you might not be doing that. Nothing might be going to your surviving partner. And I've definitely seen that happen. If each person who comes into the relationship is independently, they have their own, they've kept things financially separate, and there's kids on both sides, that might not be the way that you want to go. I'd say probably more often than not, the answer is yes. We are going to be giving everything to the surviving spouse or partner first. But that's definitely one decision, because that will kind of simplify the direction that this goes based on that answer to that question. And then the second, more difficult decision would be if both of you have passed, then how are things divided up? If you have more than one child, especially, or is everything going to them equally? Are there different percentages for each child? You know, and I think it's different if you have grown kids and you see a lot of times like one child's struggling financially, so you want to give a greater percentage. But then especially for people that have kids who have disabilities or kids with special needs, I mean, in my own estate plan, I have everything going equal shares, but I have 3 kids, so you can't do it exactly equally. So the extra goes to my son who has special needs. And I've been very clear about that. Everyone knows. But there's a lot of reasons why, right? Like you would want to give a greater percentage to one child, especially if you have a child with special needs or a child with disabilities. It makes a lot of sense. You know that child's going to have a greater financial need, probably for the rest of their life. So that's one thing to think about when if you're thinking through where do things go after both of you have passed. And then I'll move on to the third decision, if that's okay.
Yes, yeah, please.
Okay. Yeah. So here's where we're going to kind of dip our toe into trust language. So most of the time when you have young kids, and particularly if you have a child who has disabilities, you're not going to want them to inherit anything from you outright. We're not going to be writing a check directly to them, hopefully. So more often than not, you're going to be talking to an estate planner about setting up a trust for the benefit of your children after you pass away. And there's lots of different types of trust. And my goal is not to get into the nitty-gritties of what type of trust. That's the job of an estate planner, to walk you through what type of trust is the most appropriate for your situation. But I will tell you, the basic concept is to take an inheritance and put it into the hands of somebody else, which is a trustee, and to say in a document how you want the money to be used. A trust allows you to kind of control what happens to those funds after you've passed away. So that's what you want, right, for minor children, to kind of, because you don't know what could come down the road for them. If there's a bad marriage, if they themselves have a child with special needs one day, if they need it for tuition, medical expenses of their own, that's the purpose of the trust, that it's there for them for as long as they need it. So you'd be deciding what you want the trust to pay for, who would be the one in charge of the trust, that person we refer to as the trustee. There's a whole separate topic of special needs trust or supplemental needs trust, which we're not going to get into today, but we definitely will be talking about. But I think the important thing in a basic estate planning conversation is to know that when you have young kids, or when you have a child with disabilities or special needs, you're going to be setting up the plan to prevent them from inheriting outright. And the way to do that is using a trust. So you outline in the trust how you want the money to be used, and you select a person to be in charge of that.
Well, and so for trustee, I know you said this, but just to, make sure that everyone is, speaking the same language, this person would make the financial decisions for the trust and therefore your child. Is that correct?
Actually, so the trustee, their job is to carry out the terms of the trust. So it's different from a guardian or conservator. That's a different, it could be the same person who fills 2 different roles in the legal world. You could select the same person to fill both roles. You could select 2 different people, right? You could also select 2 people to serve as trustees together. You might pick a corporate trustee. There are banks that have trust departments, right, who can serve in that role. And there's lots of reasons why that might be a good choice for you. But no, they wouldn't be making any decisions about the person of your child. So it's a different role. Their job is to carry out the terms of the trust. So if your trust says, this money's here for as long as my child needs it, up until age whatever. You could select an age, right? Like where the money goes to them outright. I've seen a lot of people do that. If your kids are really, really young, then you might not put an age in there. And the trustee their job is to just manage the money for the child for as long as they live. Eventually, as your kids get older and you see what direction their life is headed, you might change the trust and say, they seem like they got it together. I'm going to let them have it at age 35, right? I'll tell you, I've had people tell me, like in the past, I want them to get everything at age 25. And I'm like, that's not.
It's like, I would like to have met you at 25. Really?
I'm always like, I'm such a pessimist because I would be the person like, what if they get divorced? Oh, we don't believe in divorce. Well, you should, because it's real. It's a real thing that could happen.
And your child might feel differently. So, yeah.
Right. Divorce is real. I'm just saying. So, but the point is to know, this is the document where you make those types of decisions. So when you sit down with your estate planner, you want to ask them, look, when I feel very strongly about not using this trust for, whatever. I don't want my kids to use it on an expensive car, or I only want them to use it on tuition. But talk through that with your estate planner. That's the point of this document. And then who would serve as trustee? That's your decision. Something your estate planner should give you advice about as well. Why you would want to choose one person over another, or why a corporate trustee is appropriate. Those are all decisions that you'd be making.
Right. And then decision 4, another really important role, obviously, which is, I think it has to do with guardian, right?
Yes. Who is going to be the legal guardian for minor children? Oh man, this is where a lot of people get hung up, right? Because how can you make this decision? How do you do it? Really?
Yeah. Even thinking about it is,
it's
right?
hard to think about. Yeah.
It's really hard to think about because, of course, like I have to say, right, on most days many parents are thinking, I messed this up, right? Like not doing great. But then when you're really thinking about that, it's like, no one's going to be able to do this. Like I can do this, right? I mean, you are the parent, and it's obviously lots of emotions with that.
Yeah.
And a lot of our kids are not, not that any child is easy or, comes with some manual, but our kids are.
My kids are terrible. So.
Did you say your kids are terrible?
Mine are. They're awful human beings.
Like, who would want these children?
Oh my gosh. Look, I tell people all the time, do not have kids. Yeah. Don't do it. Let my life be a warning to you. No. That's a joke. My kids know that I love them, and I tell them this all the time. And when I tell them, they just laugh. They don't take it seriously. But anyway,
it's the dark parent humor. We all get it. We're all there.
Totally. Yeah. Well, yes. And also, you already know my husband's been traveling, so it's just been me and them for a lot of this spring, summer. So they don't take me seriously at all. I yell at them all the time, and they're like, "Yeah, whatever."
Unfazed, Mom, unfazed.
Yeah. Yeah. So no, you should select a guardian, right? Like, and I know that's hard to think about on most days. Like for me personally, I'm just like, I'd be more than happy to hand this to somebody else. But no, I mean, in an emergency, something happened to you and to the other parent, then you have to have somebody selected to serve that role. That it's your responsibility, okay, as a parent. You have little ones who are depending on you. And if you're the only one with authority to handle things for them, you owe it to them, right? Like it's not a decision we can kind of skirt around. If the kids are depending on you and you're a mom, you're a dad, or whatever, you have to select somebody to be your backup. And it's not an easy thing, and no one is going to be as good as you at it. Except for I have a few babysitters where when I leave my kids, like, look, you're in better hands, honestly. I'm leaving you in better hands. But nobody's going to be as good as you. We already know that. You're the best person for the job. You're selecting the next best person, okay? And you want to talk to that person and make sure they're willing, obviously. When you have a child with special needs, a child with disabilities, so much more goes into that. It's not just a conversation. I mean, my husband and I have dear friends of ours, and also my brother and his wife, who are in the process of learning the ropes of how to take care of my son, because I can't be the only keeper of that information. I'm a human being. I could get sick. Something could happen to me, and I need somebody else to step into my shoes and keep on doing what I'm doing. So don't let that be. I don't ever want to see a parent let this decision be the reason why they don't do their estate plan. Okay. I mean, you select somebody, it's not easy. You have to do it. But it allows you to lay your head on your pillow at night, right? Like, if you know you're not the only one, if something happens to you, this thing will keep on going. Is it going to be perfect? Probably not. I mean, are you doing it perfect?
No.
If you are, let me know, because I'm not.
No, we're all scarring our children. But on a daily basis.
Somebody has to have authority to step in if something happens to you. So don't let this hold up the whole process for you. I've seen that happen, and I feel badly that people can't get past that hurdle. I know it's not pleasant, but it's something you got to do. And let's see, the fifth decision, which is an easier one than the one we just went over.
Right, the paper pusher, right? The paper
pusher. Yeah,
and
a lot of times, like, an easy way to deal with this one, who's going to be the one to handle the paperwork involved in your estate? A lot of times I'll say make it the same person who's your agent under power of attorney, because they might already be familiar with your finances, right? Like, so it makes sense to name the same person, but it might not necessarily be the one who's serving as trustee. It might not be the one, who is serving in any other role in your estate. But you do want somebody who's organized. If the person has experience in handling estates, even better. I've had lots of people ask me to do it.
I was just going to say,
I just hide under my desk. Like, I get texts all the time, like, from family. Hey, what type of attorney are you? Those are the ones I ignore. I ignore those completely.
Nope.
I'm busy.
I'm busy today. I think, though, that's the really important point. I recently actually, I was put into a friend's, estate planning trust, like care of their child. And, they had all of the people involved with their estate planning and trust. We all went over there for dinner. We had great wine and, just really meeting each other. But the important, and it really struck me because, I think a lot of people think of one or two people, right? They're thinking, okay, somebody that's going to watch the kids, somebody that's going to oversee the trust or the finances, right? And I remember that's sort of how it was put into my head when my daughter was young, and that it really can be like different people that you trust or have different strengths, and really kind of your village coming together in different ways to make sure that your child's needs are going to continue being met.
Yeah, and just personally, I don't mind, and I have in my own estate plan different people serving in different roles, because I think it provides some checks and balances too.
Yeah.
Because as the child gets older, you don't want to. I don't want my kids to think like, well, you know how teenagers are, right? Like, I'm always thinking like, what if I wasn't around, and what if I, as my kids reach teenage year age and they want to use money for something that the trustee says no about. Like, I want to have enough people involved so it's not so much authority in the hands of one person. That's just me personally. And you might have a totally different situation and you're not worried about that. That's totally fine. The important thing is to know what kind of decisions you have to make and to make them. Because if you don't make them and there's an emergency, somebody else is going to be making them for you. And they're probably not going to be your first choice, right? And you won't be around to have any say in it. But I'm a big proponent of, if you have a chance to do it, for the good of the people that are counting on you.
Right. Absolutely. And that's what keeps, even from the first time that we talked, that's what keeps playing in my head, right? I mean, avoiding anything because of our own discomfort doesn't help the people.
Man.
Obviously, all of those around that are going to need that help.
Yeah, definitely. And I mean, thinking of all the difficult things that we do as parents on a daily basis, like, I'm here to tell you it is not worse than that, okay? It isn't. It's not. For the last few days, we have a nighttime nurse here with who helps us with my son. She's usually here in the evenings. We've had for the last few days of a scheduling issue. But we have a daytime nurse and a nighttime nurse. But so I was in charge of all the baths and like getting my son into bed and hooking up the pulse ox and his braces and the feeding tube and all that. I was like, okay, I don't. Where do I clock out?
Yeah, right.
I did not sign up for this. I'm just telling you. But no, I mean, of all the things that we're doing as parents, especially if you're the parent of your parents of children with disabilities and special needs, like all the meetings, right? The IEPs, my God. I mean, therapy, medication, all that stuff. This is not more difficult than that. You're already doing complicated stuff. You can 100% handle this. It should be, an estate plan should not be something that is intimidating to you. It shouldn't be over your head. If you're meeting with somebody that's talking at you and not with you, that's probably the wrong person, in my opinion. You want somebody who's gonna make you feel like this is the pieces of this are in place. And as my family grows and changes, and if my situation changes, if there is a divorce, or a lot of people have children that have special needs that worsen over time. So when you have young kids, you might not need a lot of complexity in your plan, but as your child gets older, you may need it. And you want to have the type of plan in place that you feel like I can get my arms around it, and I know that this piece needs to be changed, right? Or that piece needs to be changed. So I really want people to feel that they're in control of the process, if that helps at all.
Yeah, no, that's a really great point. So and you're completely right in that we're doing the hard stuff every day. This is just making sure that will continue.
This
right?
is not any more difficult than what you're doing. Yeah,
exactly. Yeah. And so, all right, these are, these 5 decisions, right, about assets. After we've determined sort of these 5 decisions, you said that there are 3 things that we need to remember about distributing our assets. And I think number 1 was make sure that your beneficiary designations and titling of your accounts work with your documents. So
yes.
What does that mean?
So that means that once you have all these fancy documents in place, and you probably are like, my God, like I had no idea that was going to cost that much. Once that's all done, you're not done. Okay. You do need to sit down and make sure that if you've said that everything is going to a trust for the benefit of your kids, you want to make sure that your bank accounts, your life insurance policy, your retirement plan account, your brokerage account, if you have stock certificates like that you inherited from a grandparent or whatever, you want to make sure that everything, the titling of all that is set up to work with your documents. So if you have a life insurance policy, for example, that you've had since before you were married, and you have your brother on as the beneficiary, well, guess who's that's going to go to? It's not going to go to the trust for your kids. It's going to your brother. So, right, like this is the stuff we kind of have to think through. If you're recently divorced, I mean, important to go through and make sure that you've taken your spouse's name off of your accounts as a beneficiary, that the kids or the trustees of their trust are on there. And your estate planner should be holding your hand and getting you through that whole process. It's not enough just to have a binder full of documents and they hand it to you and then they send you on your way. You do want to make sure that this piece of it gets done. Okay, because things get lost, right? Like I wouldn't trust the bank to make sure that all this is done correctly for me. I definitely wouldn't. So you do want to make right.
No,
I wouldn't. So if you have a financial planner, which I recommend having one, but as an aside, but if you have a financial planner, you want to call that person and say, here's the name of my estate planning attorney. Talk directly to them and make sure that the titling of my accounts works with my new documents that I just signed. That's the easiest way to do it.
Yeah. Well, and one thing that you said when we were discussing this before that I think is really important to kind of hit home is that beneficiary trumps the will.
Yeah, and a lot, yeah. And I know that in Maryland that's the case. I know in a lot of states that's the case. I mean, just think about it. If the life insurance company is not, it's probably not based in the state where you live, right? And if you've had that policy before you did your estate planning or even after your estate planning, and gosh, I've heard people say, if I had a nickel for every time I've heard someone say this, oh, I'm just going to leave it to my brother, or and he'll know what to do with it after I pass away. That is so risky. You have no idea what the situation could be after you die, right? Like you have no control over what that person does with the funds. You've paid a lot of money and gone through all the pain of getting these decisions put into place. Make sure that your account titling the beneficiaries, joint owners, all of that funnels everything through your estate plan. Don't leave it in the hands of somebody else. And if the bank has made an error on a beneficiary designation, it's your job to find it and get it corrected, right? Like while you're valid, you can do that stuff. I've seen banks make mistakes in my own accounts. I updated the kid's trust, so I had to change the beneficiary designation, and they still had the previous date on there, right? So that kind of thing happens. You have to be on top of it.
Yeah. And yeah, I have to be on top of everything. And that, I guess that's the underlying thing, right? You can't trust that anyone else is going to always get it right. So like everything in our lives, like our eyes have to be on everything. So it's one more hat that we're going to put on, right? Definitely. All of the different hats we wear, and then this one as well, maybe the most important.
Yes.
Right. Yeah. And so number 2 was, you say that we need to review the will or trust every year.
Yes.
Why?
Yeah. Because there might be provisions in there that you no longer need, or you might need to add provisions to it. I would say once a year, or sooner if there's a major life event. There's a marriage, a death, or a diagnosis, right? Like that causes you to start thinking, oh, do I need to change this trust to a special needs trust? Did your child start getting government benefits this year? Do we need to make some adjustments to the way that they're going to inherit from you so we don't interfere with that at all? That's down the road of special needs trust, which we are going to talk about, not today, but we will be talking about it. So yeah, once a year, because birth, death, marriage, divorce. You might have named somebody to serve as guardian. You've had a falling out with that person. Now you don't want them involved anymore. Best to kind of review those things. Like I've had people sit down and look at the document and say, my God, I had no idea that I totally forgot that this person was going to be serving as trustee. I haven't talked to them in 10 years, So it's for that reason you forget. Okay. I mean, I'm not a person that would remember everything in my document. So it's a good idea to sit down, review your plan. If any changes need to be made, make them while there's no emergency. It's not easy, to get a hold of an estate planner and say, I need you to change this, and I need it done immediately, and also I'm in the hospital. So.
Yeah. Excuse me, I need to go get a test done. Let me get right back to you. Yeah. I think that's also the point that you keep coming back to, which is really important. Like, do it while you can, and everything. Yeah, exactly. Because the one thing I think we can all count on, no matter what, is that life is unpredictable, as we all live that very well. And and there's so many details to remember everything that it's really important just to
do the exercise, right? Just decide. And every summer, I'm going to sit down and pull up my documents of this and make sure they say what I want them to say. Maybe you feel differently about your medical decisions. For whatever reason, you might want to update things. So at least once a year, I would say, get them out, look at everything, make sure they say what you want them to say.
Definitely. And I mean, number 3, I know, again, we'll probably get more into this when we talk about special needs trust, but you talk about trust versus will. So what do we need to know about that? Find out if. Yeah, I think it was find out if a trust, a will, or some combination of both is the best.
Yeah. I know that a lot of people are familiar with revocable living trust. That's kind of the trust that most people have heard about. And I'll tell you, it's not necessary in every state. One of the primary purposes of having a trust besides just giving you control from beyond the grave, a trust is the vehicle that allows you to do that. So we talked about how it allows you to prevent your kids from inheriting outright, and it puts some strings on their inheritance. It also can leapfrog over the probate process, and probate in some states is pretty terrible. Like, I know New York has a really awful probate proceeding. So what some people will do is establish a trust, and that exists while they're living, but we don't get into like distributing assets or anything until after a person passes away. The purpose of that is to avoid all of probate. And that type of trust, I think the easiest way to think about it is like an LLC. It exists as a separate entity. You kind of put everything you own into that entity, and that entity is separate totally from probate. It has nothing to do with probate. Depending on the state that you live in, that might be the way you want to go. I know, for example, Florida has a lot of probate problems. New York does.
I would imagine it's probably not fun in any state.
Maryland's not too bad. I will be totally honest with you. So a lot of times, and I'm not, it's probably why I'm not doing estate planning anymore, but I would be the type of attorney who's like, you don't really need a standalone trust. You can honestly just handle this with a simple will. And because probate in Maryland is not super expensive, it's not super complicated. In Maryland, thankfully, we have a really good register of wills in each county. In my opinion, unless there's a really good reason why you need a complex trust, I usually tell people just do a simple will. I don't practice in that area anymore, and everyone's situation is different. But I do think you want to make sure that you understand with an estate planner why they're recommending a trust to you. And it may be that your situation requires several trusts. That could be, for wealth management reasons, or to avoid estate taxes, to avoid probate. But the point is to make sure you understand why a trust is being used, what happens to the funds in the trust after you pass away, who's going to be in control of it. Those are the important decisions. Still same decisions that you would need to run through,
And then when you're talking about trust right now, that's different than special needs trust?
It could contain special needs trust provisions. It could. So the special needs trust provisions, and I have them in my own personal estate plan for my son. So those provisions basically say this money is here not to interfere with government benefits. Whatever the government is paying for, this money in this trust is not going to pay for that stuff. The government's paying for it. It's much more complex than that. I've really oversimplified it. But you can take those provisions and put them into different types of trusts, right? Like you could put them in a trust that exists in your will. You could put them in a trust that exists totally separate from your will. You may have a combination of both things in your estate. Like I've seen that happen with people who have large, complex estates or different types of assets that require different trusts. If you've got, I would say, I hate to use the phrase run of the mill, but if you've got kind of a run of the mill estate that we're dealing with, like not a young parents with young kids, one of them has special needs, not a ton of assets. And if somebody's recommending what sounds like extremely complex trust, I think you want to understand why that's being recommended to you. What is the purpose of it? Why am I trying to avoid probate so badly? What are we accomplishing with the use of this trust? So just know that in different states there are estate taxes, there are inheritance taxes, and trust might come into play to kind of avoid or mitigate those issues. Yeah. But yeah, you can use estate special needs trust provisions in those trusts as well. Definitely.
Right. And like you said, obviously state to state can vary wild. I know a lot of, I saw Lisa's comment, a lot of people, it's recommended in California, especially if you're in a homeowner, to look at trusts. It's just like you said, state to state, talk to your estate planner and individual and what everything that you're dealing with your family to come up with, what's best for you.
Yeah, definitely.
And you don't need to know all of it going in. Ask all the questions. We're giving you those questions. So if it feels a little overwhelming, don't worry. You don't need to understand all of it, everything that we're talking about today, but you need to know the questions to ask so you can talk through all of those things. So don't feel overwhelmed, even though it is a little overwhelming. So, all of it. But so for medical, financial, and asset distribution planning, Are we talking about, we've mentioned kind of a lot of different players. Are we talking to 3 different professionals to help plan each of these? Are we dealing with an estate planner, an estate attorney, a financial planner, anyone else that I'm missing? Are there different people for each of these decisions?
No, I think I would say you want an estate planning attorney. And if for parents of children that have disabilities, have special needs, I personally would ask the question, what kind of experience do you have doing estate plans for parents in my situation? Right? Like, I don't want to be the first special needs trust that you draft.
Yeah.
No.
No, probably just like, yeah, you don't want to be the first time somebody tattoos somebody, or
no,
it's way bigger than that, right? But the list goes on. Yeah.
Yeah, you don't want that. No, so you do want to find a person that is best suited for your situation. That person's going to be drafting your documents, the medical documents, the financial documents, your will, trust, or whatever. If you're a person that has a really, really simple situation, you don't own very much of anything, you're just starting to get into the process, and you're doing some free forms that you found that are available through your state, that's fine. If you're planning retirement and how am I going to pay for tuition as the kids get older, and you have gone through the process of selecting a financial planner, you do want that person involved, not to draft documents, but you do want them involved to deal with like titling of your assets and keeping up on your beneficiary designations. I have a financial planner. I don't have a huge estate, but I have a financial planner because I'm not an expert in that area, and I want somebody else who is, so that, when I change my documents, which I did recently, I can change the documents and send the most recent version to my financial planner and say, hey, I need to update my beneficiary designations on my brokerage account, or on my retirement plan account. I've met people who want to do all that themselves, which I think is not the smartest. I mean, there are people who go through a lot of training to do that properly. And I've met financial planners who think they want to take a stab at estate planning. Well, recommend that. In your lane, I think that's important. So, yeah, but I also do recommend talking to your doctor. Some of the questions for an advance directive are not legal questions. Some of them are medical questions.
Right.
Yeah. So definitely talk to your doctor if you have questions about, hey, if this were the circumstance, if this was my condition and my spouse walked in with this document, how would that actually be handled in real life? That's not a legal question. That's a medical question. So get your doctor involved with those types of things. Or if your estate planner is trying to answer those questions for you, they don't know. They're not doctors. We're not the ones that you call in the middle of the night.
Right. Yeah. No. Red flag. We're identifying some red flags, or at least some things to watch out for. And I'm looking at the time, and I know there's just a couple. Maybe I can do some rapid fire questions.
Yes. Yeah.
Because just each of these could be their own complete event. But what is the biggest mistake that you see families making with estate planning?
The biggest mistake, honestly, that I have seen is not understanding the documents. Just not understanding what the documents say. So sometimes I've seen people do estate planning early on, kind of a knee-jerk reaction. Oh, we have kids now, we should probably hurry up and do this. And then when they actually are ready to sit down and kind of go through everything, they haven't made decisions that made sense. The documents, or the online forms, especially for wills. Can I just tell you not to do that? Don't download a form. I litigated those. They're extremely messy and can create a huge problem where otherwise there wouldn't have been one. You'll spend thousands of dollars in litigation after the fact, and you could probably just get it done for much cheaper at the beginning and save your loved ones a lot of headache. So those are the big things that I've seen people do.
Okay. Yeah. And this is probably going to be, an annoying question because it's going to vary state to state and the scope of what you're trying to do. but like, how much can families sort of plan on spending for estate planning?
Yeah, that's a great question, honestly. And I can kind of, because of the experience that I've had, I can kind of pull back the curtain a little bit and talk about like legal fees. In Maryland, I would say, like where I am, which is not in a big city in Maryland, I would expect personally to pay somewhere between like $2,000 and $3,000 from beginning to end for an estate plan. Is it important how much it costs? I think what's more important is that you know what the costs are going to be going in. And it's impossible really for a lawyer to tell you without knowing any specifics of your situation. It's impossible. I've definitely had people ask me, well, I want to know how much it's going to cost. And how can I answer that question if I have no idea how complex the situation is? So I think if you can ask the attorney generally, like for an uncomplicated situation, I don't own my own business. We don't have a blended family. It's not like, and there's nothing strange going on here, right? The most complex thing is that I have a child with special needs and we are going to have to plan for that. But give me an estimate, like a roundabout, or if they use a flat fee, you want to understand that going in. It shouldn't be a big surprise at the end, right? Like, so definitely ask that question. Don't be shy about it. Do look at the bill and make sure you understand it. Mistakes happen on bills that are issued by attorneys. So you want to know going in what to expect.
Yeah, absolutely. And, you know, one of my favorite things that this is just sort of a sidebar of what we're talking about, but one of my favorite things that we've discussed when talking about this entire series is how you organize all this information, right? Like, we're talking about all this stuff. There's so much, and then we have to organize it. And we're definitely going to cover this in more detail in the future. But if you can give us one amazing tip about organizing all of the information that we are discussing today. I mean, do we just throw it in a Google Doc, share it with anyone involved in our estate planning, and call it a day?
Yeah, so, okay, this is one of my favorite things to talk about because I don't think that there is much out there to give good advice about this specifically. And you can do all the fancy planning in the world, but if it's kind of all over the place and nobody knows how to get to it, how helpful is it really? So what I will tell you is, I think you should select the process that works best for you. Okay. I mean, you're going to see, if you Google this topic, you're going to see that there's people selling binders with tabs. There are like kits that you can get. Some people say write a letter. I would say use what works for you. Okay. My system is files. That's what works for me. I have a file for each bank account. On the inside, you'll see username, password, beneficiaries, co-owner. All that information is in a file for each account. I've got like a list of debits and deposits that are going in and coming out. So that it's my brother who would be handling things if something happened to both of us. And I want him to know from opening the file, what do I need to pay? When does this mortgage pay? Right? Like, where are the kids' health insurance cards? When was the last time we ordered medical supplies? Right? Like, who are the doctors? Where do I find their information? All that stuff, you do have to have it organized, especially when you have a child with special needs. But I would tell you, pick the way that works best for you. If it's a Post-it note system, fine, but do it, right? Like, if you pass away, after you pass away, say if, but all of us are not going to be here forever. That's the thing that's going to happen.
All in that boat, yeah.
Yeah. After you pass away, if you have not organized this, it will take months for your loved one or the person who's going to be in charge to track down usernames and passwords. I mean, you think Gmail is going to hand that information to you? No. Do you think Bank of America is going to? Absolutely not. So, I mean, the easiest way to do it is when you go through and you pay your bills, start writing that stuff down or put it into a Google Doc. But whatever way works best for you, do that. And make sure that the person who is in charge knows how to get to it. Okay? I think I told you my brother keeps his important stuff in a fossil tin on his dresser. And that's whatever. Now I know where it is. Do what works best for you. If it's a letter, binder, whatever. Just do it though.
Yeah, and just make sure your people know where to find it.
Yes.
You know, files, Fossilton, wherever it may be, right? And even what you just said, like something you've said over and over, we don't want to do this, but we have to do this. So we have to do it. We have to do it well, and we have to understand it. So you have any last words for our parents?
Just an encouragement. You can do this. Okay. You can and you should. So yeah, and don't just do it for your kids. That's a great reason to do it. It is a great reason. Also do it for yourself, for your own peace of mind, you know? And if you wanted to skip town for a couple months and leave someone else in charge, hand them your power of attorney and be on your merry way. I'm just saying. Yeah, do it for yourself. Do it for your kids. But don't be so intimidated that you let that get in the way of going through with this. There's too many people counting on you, and you've done the hard work. My gosh, like who could even understand all the hard things that you've done up till now? And you don't want to see that undone if something happens to you. So you owe it to yourself to get this done.